What's going on, everybody? Doing a video tonight. It's Saturday night, so it means I'm working. So that means I'm on here, I guess. So, topic tonight is going to be my experience as it relates to being a legal aide and just the whole prison legal system and how that works and what that means for you as an inmate and what that means for society. So, that's the rough topic that I was thinking about doing tonight, and you can kind of see how there's parallels and how case law and things that can happen to people that are in prison when they file lawsuits and how that can come out and relate to things out here. So, as I may have mentioned before, while I was in custody, I did go through a training that was offered by the Department of Public Advocacy here in Kentucky, and they're basically the state's public defender's office. They have offices throughout the state, and if your case is referred to them, or if you meet the requirements to have a public defender, then someone from that office will take over the case as far as defending you from a criminal defense perspective. So they have every year in the Department of Corrections, they offer a 3-week course that basically takes an inmate that knows probably nothing or very little about the law as it relates to Kentucky and especially criminal matters. And then at the end of that 3 weeks, you get a pretty basic foundation and grasp of how the law is supposed to work and what processes you have, what remedies for appeal you may have, and things like that. So the course is a co-ed course, I guess, if you want to call it that. And there's at the class that I went through in 2013, there was a handful of women from the women's prisons that were there, but mostly it was male. And you have to there's kind of a selective process to come to that training. Actually, it's kind of strange, but you take a short test. It's just a basic aptitude kind of test, and you pass that. And then each facility, I think at the time the rules said that each facility could nominate 2 people to go. And then you would go to one facility. And the facility you go to is called Luther Luckett Correctional Complex. It's in LaGrange, the same place as the State Reformatory, and also the main men's receiving prison. So you report there, you go there. You're housed there as a regular inmate at Luther Luckett. And your job every day, I guess, is to go to class every day. In class, you have... it's all taught by the Department of Public Advocacy, again, the Public Defender's Office in the state. And you have, typical trial attorneys. You have appellate branch attorneys. You have capital appeals people that are involved in the course. You also have Department of Public Advocacy paralegals, and you also have mitigation specialists that come into play with this course as well. And they all have a function. They all teach a certain part of the course. I can tell you, having right now I'm in my 3rd year of paralegal school in the civilian world, and I'm in an actual accredited school. I'll have a bachelor's degree here in about a year in paralegal studies. The coursework for this class that the prisons offer, the Department of Public Advocacy Officers, is pretty intense. It's a lot of reading, a lot of research, and I think to an extent you have to have a certain type of mind coming into it in order to take this course and be successful. There's several topics that are taught. It's 3 weeks. It's very condensed. It's pretty rapid fire. And at the end of that, you have basically a final. And so as a final exam, you have something in Kentucky. It's under the criminal procedure rules. It's called an 1142. 1142 is where a person under a sentence, whether it's probation or active sentence of custody, you can challenge your conviction and sentence based on ineffective assistance of counsel. And where this comes from is a Supreme Court case called Strickland versus Washington. Under the Constitution, you have a 6th Amendment right to not only to counsel, but also to effective counsel. So if your lawyer comes to court every day and just sits there and never says anything and never does any investigation and never asks any questions and never tries to refute someone's credibility, then is he really being effective? And I would say that he's not. So you have the right to assistance of counsel, but also the competent, effective assistance of counsel. And under this 1142 procedure motion, you're basically claiming that your counsel, your trial counsel, was ineffective. They were incompetent, or they made gross mistakes that the average attorney in a situation similar with some amount of experience wouldn't do. So if you're successful on that, then you open up a can of worms. So basically what you have to do at the end of this course is you have to draft, they give you a scenario, a fact pattern, a scenario, and you have to draft a 1142 motion, and they grade it, and they give you lots of feedback. And there's no shortage of red ink on mine. I did pass mine the first time. Some people don't. And if they don't, then they have some discretion as far as what to do about that. But again, the coursework's pretty difficult. It's a lot of reading, a lot of memorization. You have to know a lot of case citations. It helps to have a kind of a cheat sheet, a list of cases that relate to criminal law in general, but also to appellate type work and that kind of stuff. So the way that it works is that after you get finished with that course, you go back to the prison that sent you. So whether that's a medium, minimum, maximum, whatever it may be. The reason that legal aids exist to begin with is there's a consent decree that is in place, was in place. And the consent decree is under a case called Kendrick versus Bland. And there's a lot of things going on in Kentucky prisons. Back in the day, several years ago, there was only 2 prisons in the whole state. There was a state reformatory in LaGrange, and there was a state penitentiary in Eddyville, and that was it. They didn't have any of this minimum security, medium security stuff. There was 2 prisons, and that was it. At one point in Kentucky, they only had 1 prison. It was in Frankfort. So as part of that, they were supposed to offer the assistance of attorneys. Well, there was issues where the attorneys couldn't show up. The lockdowns and those kinds of things kind of made it an issue. So they decided that, hey, maybe we should just not let them come in. So that was what that was serving to do, was to limit people's ability to have access to the courts. So the consent decree came forward in this case, and it's been set out that every prison is to have a legal aid system where these are inmates that offer, and it was a pretty smart, pretty smart compromise that the state reached with the federal government and with the parties that were involved. So the Department of Public Advocacy in Kentucky trains inmates to be legal aids to assist inmates in their cases, and the wording of it and the language of the policy is very strange in some aspects. I'll try to put the links in the description below to what I'm actually talking about, to the Kendrick versus Bland case, and also to the policy and procedure that relates to legal aids and that kind of stuff, and legal law libraries. So, after you go through this course and you get your legal aid certificate, then you go back to your initial prison that you were at, and you're a legal aid. That's your job. I can tell you that it was very difficult in a lot of ways, because the prison tends to rely on you for a lot of things. And, one of those things is that, you have to help inmates with their cases, and with that means their criminal cases, and that can be a double-edged sword, honestly. I had one individual that I agreed to help, and it wasn't out of anything else. It was because I believed at the time that he was innocent. I found later on that he wasn't. He was very guilty of everything that he was accused of and more. So, but he had a sex related case, and I generally stayed away from those for lots of reasons. I decided to help him, or try to, and it kind of blew up in my face, and so, whatever. But you get individuals that use a shotgun to kill their wife or their best friend or someone they didn't know, and they have all of that material. When you go through a criminal case, you have discovery. The discovery in there has pictures of the crime scene, typically. It has autopsy reports. It has medical reports. It's going to have other things in there that to the average person may be disturbing, honestly. And if you're legal aid and that person has maintained that material, then you may have to look through it to try to help them, to do a good faith job to try to help someone in that situation. The state thinks very highly of you if you're legal aid because they pay you $1 a day. So for me, it wasn't really about the $1 a day. It was about helping people and trying to I guess apply my ability to understand the law and to practice it in the controlled sense that I could. And I want to clarify, when I was in prison as a legal aid, I was not an attorney. I never professed or claimed to be an attorney. But there were things that I could do that the average inmate couldn't. And there are things that under the consent decree, the Kendrick versus Bland consent decree, that it specifically allows me as a legal aid to do, the average inmate couldn't do. So as a legal aid, you can't draft motions and sign it John Smith attorney or John Smith legal aid. That's not how it works. Basically what you do in appeals and in criminal matters and that kind of stuff is you prepare a motion for someone, you give it to them, they sign it, and they send it into courts as themselves. So you're effectively a ghostwriter at that point, which that's fine. But, if you have someone that, that files a motion on, a napkin, and they send it in the court, in some cases, and there's some, colloquial examples of this, but people have filed motions and sent it on toilet paper, and it's gotten heard by the court. But someone that actually has the right font, the right formatting, and every court has their own unique things that they like and don't like. So as a legal aid, your job, and you have the ability to find the local rules and the court rules that relate to, what that court likes or wants or needs or has to have. You have a few different responsibilities in that. You have to spend some time down at the law library every day. That's your job, so you have to be there. You have to be available for inmates to come in and ask you for help. That does not mean that you have to do what I'm going to call bullshit or garbage legal work for someone. If someone says the tooth fairy is my cousin, so I should get out of prison, and they want you to file a motion saying that, you don't have to file that. You don't have to write that. You can tell them to go down the road or do it themselves or use a crayon or find some toilet paper. So the rule that I always had in my mind is I didn't want to be accused. I didn't want to be known as someone that filed frivolous or harassing material in court, because there's some real consequences that can occur to that. That can happen with that, and you don't want them, honestly. Corrections policy allows for it, and state and federal law allows for it. So the court can censor you, they can issue fines, and in certain cases they can mandate prepayment of filing fees, whereas ordinarily as a prisoner you're going to get a waiver of those filing fees. So there's some pretty significant consequences that can happen if you just go and file anything and everything in court. They can also take your job from you. They can take your legal aid certification and your ability to be a legal aid in prison, which I can tell you as a legal aid, I was maybe not liked all the time by everybody, because a lot of people thought that you worked with the guards or with the authorities in prison, and that wasn't the case. You were just always there, because this is the other side of being a legal aid, is you have a lot of administrative hearings, and those hearings are disciplinary report hearings. They're not fun. They're honestly, the reason that you're there is because of this federal consent decree. Other than that, there's no purpose for you to be there. If the individual that's accused or whatever the report is, as long as he's not licking a window, your purpose really isn't any point to be there. The only purpose you have in that situation is to bring up due process concerns and to mention them, not even to argue and litigate and fight. That's not your job. You're not a lawyer. Your job is to mention those, because the average inmate isn't going to know about those things. They're not going to know what due process means. So you mention those things, so if they go to an appeal that they won't be able to understand how to fill out, they can maybe cite to an issue they don't know about. It just doesn't make a whole lot of sense in that sense at all. But there was situations, and I can recall specifically, that something wasn't right. The chain of custody wasn't right. That's a due process concern. The name on the chain of custody was a different name of the person that I'm helping to help in their report for having tobacco on them, whatever it may be. Starting in 2012, Kentucky got rid of tobacco. They made it contraband, made it dangerous contraband in some places, and the things that go with that, dangerous contraband. So tobacco was completely forbidden in Department of Corrections facilities. A lot of the reports, honestly, I can tell you, are from that, and there's a lot of expense that goes along with that, with transferring people that get written up for having tobacco or materials, and then they go to another facility because their point score or classification level goes up because of that report that they're being given. It's a big headache, but that's a lot of what it is, honestly. You have other situations where someone does something in prison that potentially could be another felony, and those are a little more interesting, I think, from a legal perspective, because what you're doing is actually going to be made a part of a record. The state police, the protocol in Kentucky is if an inmate commits a crime in prison, which does happen, then the state police is the lead investigating agency. Say it's an assault, a sexual assault, a homicide, something like that. State police is the lead investigating agency, kind of like with federal inmates, the FBI is the investigating agency. So you have the court call responsibilities you have the helping people with criminal type things, and you also have kind of ancillary things that may come on the side. Every facility that I was ever at had the old school guy that had been doing it since been doing it. And I was never one of those guys. They had they were set in their ways, I guess, is one way to look at it. But they had their emotions, they had their cases they knew, and it didn't matter that those cases changed every year or every 6 months maybe, because something comes along and supersedes that case, and you have to make sure to check it, whether it's check the currentness of it or shepherdize it, to make sure that case is still valid law if you're going to cite it. Because if you cite a yellow flagged or a red flagged or a bad case, you're not going to get any kind of traction at all in court. So it does happen, though. I tried to be, not say more hip, but I tried to be more abreast of cases that came out. One of the things that's required is to have LexisNexis. It's switched back and forth. The Department of Corrections switched their providers back and forth. They either had LexisNexis or they had Westlaw. Personally, initially they had Westlaw, then they switched to LexisNexis, and that's what they had when I was released in 2015. I think Westlaw is a lot better system. It's a lot more intuitive. It's a lot easier to search and find the information you need without a bunch of other stuff on the side that you don't need to be reading. But either way, you have to have access to that as part of the consent decree. You also have to have copies of several different important documents: the corrections policy, the state constitution, a current copy or access to a current, which Lexis provides this, the Kentucky statutes, and also federal rules and regulations, CFRs and U.S. codes and those kinds of things. You also have to have access to, I've been to some places where the computer system goes down, and it's coincidental that it goes down, but it does happen, whether it's a vendor issue or whether it's the corrections' own internal structure, internet issues, because it is internet based. You can't get on there and try to hack into it and use it for email or something. It's just pretty much live access to case law that's coming out. So a case can be decided, and then hours later it's going to be reported onto LexisNexis, and you can cite to it. And it may have a provisional citation, but you can use that. You can know that it exists at least. I have to say, in my daughter's adoption case, LexisNexis was vital in being able to effectively pursue that, because the case that I used in that adoption procedure, when I appealed the adoption that was filed and awarded, that case came out in March of the same year that I filed the appeal. So without LexisNexis, I would not have known about that case, and that case was the standing authority that I used to get the adoption overturned of my daughter. So Kentucky does provide the basic requirements, of what this consent. I keep talking about the consent decree. I'm not reading from it, but requires inmates to have access to legal information, and it's very important, and it's for that reason. Although I had a lot of issues personally, I had a lot of issues fighting the administration of the prison I was at, because they didn't want to give the weird types of paper that every different court or state offers. I was in Kentucky. This case happened. The adoption case was being litigated in Indiana. So different states, different requirements, different colors, and those all matter. Different fonts, different sizes. It gets really weird and technical. But, in the end, I was ultimately able to do what I needed to do and file the briefs I needed to file. And I had to basically threaten to sue the warden in order to do that. But it wasn't a threat. I wasn't trying to coerce him into doing something he didn't want to do. And I said, if you don't give me the paper that I need, that I'm being told that I have to have, and if it's an issue of buying it or whatever, then I'll buy it. I mean, you all can bring it in. I use it for this, and I give it back to you. I don't care. But I had to threaten him to sue him, and finally he relented. And I've got the paperwork still, because I hang on to every scrap paperwork related to that case. But as a legal aid, you have a very important job. You have some people that come along that they are the reason and the epitome of why you're there, and they can't read. There are a good amount of people today in 2020 that cannot read. They may not be able to read at all. Or they can't read beyond a certain reading level, so they effectively can't read, especially when it gets to case law and motions and those kinds of things. While the majority of legal reading is supposed to be in plain language, it isn't always. So understanding Latin words and kind of long words for someone that has a third-grade reading level is going to be kind of difficult. And that's really the type of people that you're there for. And I had a few of those that I really kind of doubted whether they even should have been in prison to begin with, but they were. So someone else may have, with certainly more education and experience than me, felt different. But as a legal aid, you're there to help inmates, and you're there to help them to, the way that I always thought about, you're there to help them ethically fight their criminal cases. You're there to deal with administrative appeals and reports, and you're there to deal with other issues surrounding confinement, and also other things that may come along as far as family matters. Criminal certainly has family implications and adoption implications. People go to prison, they typically lose their kids. It happens. It shouldn't happen, but it's the way that, for a lot of reasons, the way that it works out, it seems like. So you have to have a kind of a jack of all trade mentality, and there's a lot of things that you may not be an expert in, you may not have experience with, but you have to kind of read it as you're going along and doing it, because this person has a deadline. I can say that as a legal aid, you're paid $1 a day. You're prohibited by rule, by policy, from accepting anything from inmates, and certainly from a quid pro quo of, I'm going to do this for you, you're going to give me this list of these canteen items. I can tell you that it happens. I can tell you that honestly that I've done that. But I would do a lot of work for very, very little. I was not. I had some legal aids that I knew, they were doing the stuff they were doing, and they had lots of money, lots of prison money, and I was never one of those people. I did the things I did for the bag of coffee that I had for that day, or for the toilet paper that I used that night, and that was it. I wasn't trying to get rich, and I didn't think enough of myself to think that I could get rich off doing the job that I was doing for $1 a day for the state. I really liked helping people, and I really liked, I guess in that sense, to me, it wasn't about fighting the system. It was more, if this person is right, then they're right. It doesn't matter whether it's the inmate or the guard or the warden or the governor or whoever it is. If they're right, they're right. So what else is there really to argue about? That kind of makes things a lot simpler. It makes them a lot more black and white, which everything isn't black and white. But it made it a little bit easier for me to justify what I was doing, as far as, I'm going to go after these people. And there's times that, you write this masterful, artistic brief or appeal or whatever, and it gets shot down. You lose, and you take it personally, because you put the research in, you did the work, and they didn't see it your way. It happens. Move on, unless you want to continue up the level of appealing that, and that's on to you. But there's one guy that I did a parole appeal for, and he was released from prison. I actually got a guy out of prison. And I cited a bunch of stuff that was relevant, because I felt the parole board screwed up. He got out of prison, and then, within a year, he was back. So, can't get mad at me. As a legal aid, it was a very rewarding job. You have a little bit of time to yourself. You can kind of do things the average inmate doesn't get to do, as far as go to a library. You work in a library typically, as most places, the way that it is. You're able to do your own private things. The thing that always intrigued me is you have tons of legal aids that are really good, and they claim to have gotten people out of prison, but they can't get themselves out, and they can't get their kids back, or they can't get that restitution order minimized, or they can't get this or can't get that. So, it's very strange in that sense. Those skills, when you come out, I think that they can probably translate to the civilian world. Back in society, I think they can probably translate if you do other things. So going through a legal aid course in prison and getting it from the Department of Public Advocacy doesn't make you a paralegal by any stretch. I think if you do that, though, I did it for 2 years in prison. And then since I've been out, I've been in school in the undergraduate program that I'm in now. So that's more of a formalization and a recognition that I do have some skills, but I'm trying to get a formal education to go along with it. There are plenty of people that get out of prison and have that kind of a background, and they end up working for an attorney that decides to take a chance on someone. They go to law school. There's several people that I can think of. I don't want to name drop, but Sean Hopwood is one person that went to prison, got out, and now he's, last time I checked, I think he's a dean at Georgetown University in suburban Maryland, D.C. He's an assistant dean there of their law school. There's several other people that have gone to prison and became attorneys. Some states have rules about if you're a convicted felon, you can't be in their state paralegal accrediting association or licensure. Kentucky at present doesn't have a licensure for paralegals. You don't have to go through a background check or anything like that. If you say you're a paralegal, then you're a paralegal. The problem with that is that in order to be a paralegal without doing unauthorized practice of law, you have to be working for an attorney and have a supervising attorney. So that's what to me personally, that's what the bachelor's degree is hopefully designed to help to accomplish. So it was a very interesting thing that I did for those 2 years from 2013 when I went through the training until 2015. When I first got to prison, one of the first contacts that I had was with the legal aid because there was a pending civil action related to my criminal case, and this legal aid helped me. He filed some motions that should have forestalled the thing that I was seeking the help for. It didn't, but that's how it happens. So I had another one when I got to another prison that helped me to try to deal with some other issues, some family issues, and got me started in the thought process of trying to become a legal aid. So when the chance came up and it was offered, I took it. I'm glad that I did, and I think that's going to about do it for my time. It's about 30 minutes. So if you have any questions, please leave them down below. Subscribe, like, share, all that good stuff. And thanks.